Welcome back to Title Talk with Title Leap, where we are all about providing agents with the tools they need to get to the closing table faster and easier. Today we're going to talk about the importance of having an attorney review your client's closing documents. Hi, I'm James Brown, founder of Title Leap and a Florida real estate attorney.
And I'm Alexandra Nieto, title manager for James Brown Law. Today we want to talk about why it's so important to have a real estate attorney on your side.
What do you got there, Alex?
We have a client who bought a property 6 years ago.
Yep.
They're selling now. We did a title report and there's open liens.
Open liens on the property. And
Open liens.
and what does your document say?
Well, of course, we went back to the title agent who originally did the closing
6 years ago, yeah.
And said, hey, these liens are open. You probably paid them off at closing. You need to make sure that they're satisfied. And they sent us this document that the buyer and seller both signed. Said, company assumes no responsibility or liability for the securing of releases of mortgages, liens, etc., which it pays off at closing. It is the responsibility of the sellers or purchasers to see that releases are properly made in the public records before the final policy will be issued.
So let me make sure I understand. 6 years ago, buyer and seller come to the closing table and they sign this document which says they're going to get their own releases. The title company pays everybody off that's supposed to be paid off, hopefully, but no satisfactions are recorded, or some satisfactions aren't recorded, and then the title company tells us, oh, it was the buyers and sellers' job to record the satisfaction.
Exactly. So they're trying to wipe their hands, and it happens from time to time where something doesn't get recorded,
Sure.
and as title agents, we help each other out to make sure that the proper steps are taken, even if it's after the fact. But they're just wiping their hands of it completely and
in
putting
this
the
transaction,
burden.
they're actually getting the buyer and the seller, because nobody read the closing documents to say, hey, we're going to take responsibility for this, so if they fail to do it, now the buyer and the seller have no recourse, theoretically, against the title company.
If
Wow.
one of them would have been represented by an attorney definitely would have read the document and said, oh, no, you're not signing this, and made them delete that paragraph.
So that kind of work we do very inexpensively. We have a transactions coordinator, legal assistant that's been doing this stuff for many, many years. We get those files in and out very quickly. We represent parties not paying for title, and it is inexpensive. And the bonus is, in a transaction like this, if there's a lawsuit, the buyer or the seller that's suing is going to name the realtor, and you don't want to be named in that lawsuit. That's just a drag on your time that you don't need. So that kind of work we can do very inefficiently. You're not going to have that burden or that liability. And does this stuff happen all the time? I can't tell you how many times I see it. It doesn't happen all the time, but I do see it frequently, and I do see people signing things they didn't read that do create liability for them.
The other issue that we've come up with, actually not recently, it was a while back, one of our investors that we work with a lot doesn't typically use us for buyer's representation. In this case, she then has started.
Right.
You know who I'm talking about.
Yep, exactly.
And the title agent, she didn't feel comfortable with. She sends us the title commitment, and immediately we see that they actually took the taxes, which should be a requirement of closing. There were past due taxes. They moved them to the B2 exceptions.
Right.
And now putting the burden on the buyer.
Right.
We saw that right away and said, no, you can't. They also had sent the commitment the day before closing instead of 5 days prior, not giving them enough time to review.
Right.
She just felt uncomfortable enough that she called us, and now she won't close without an attorney.
So I think what happened in that transaction was you had a title agent that did a lot of work for a certain seller. The seller was an investor, and the seller, instead of paying taxes at closing, they moved the taxes from the requirements section of the title commitment to the exceptions section of the title commitment, thereby giving the buyer notice they were going to pay for taxes, but a buyer who doesn't know how to read a title commitment won't understand what's going on, and then they waited till the day before closing to do it on them. Very, very nice. Yeah, absolutely. If you have a attorney looking at the title commitment, they're going to see those shouldn't be exceptions, and they should be requirements. And everybody says the same thing to me. We don't need an attorney, there's going to be title insurance. The problem is, if the title insurance is corrupted, yeah, there's title insurance, but now you're being required to do things you shouldn't customarily be doing or even required to do under your contract. But if you're seeing it in writing and you're on notice of it in the commitment, now you can't argue later that I didn't know what I was doing. So it's very important to have an attorney look over your closing documents, look over the title commitment, look over the settlement statement, look over every affidavit you're going to sign, and make sure that what you're agreeing to is what you expect to be agreeing to. Again, this work is very inexpensive to have done.
Thanks for watching Title Talk with Title Leap, where we are all about empowering agents with the tools to succeed.
Please hit subscribe and follow us on Facebook, Instagram, and LinkedIn, and stay tuned in for all our weekly content. See you next week.
Talking about soul.